Okay. And I need to go in. Okay, so if anybody, I think I've done everything I'm supposed to do, so I'll let you take over.
Great. So hello, everyone. Tonight's going to be more of an informal session, Q&A, whatever you want to ask that's coming up as part of the ONCA transition process. I'm here to field the questions and, look for legal information with you. Just a disclaimer, as in past sessions, everything is general legal information, not legal advice. So that holds true for tonight as well, although because of the smaller crowd and the loose structure, we can maybe take a bit more of a deep dive into questions. Feel free to have your cameras on or off as you like, and you can put your questions in the chat or by raising your hand. If we get through people's questions, I have a list of common questions that people have that I can go through, and maybe that will spark some more questions. Whatever the case may be, you have me until 9, so let's make the most of the time. All right. So Maria asks, once we've made our new constitution and bylaws, what do we do next? So great question. And I will begin by pointing you to the workbook that I believe it's available on the OAAS website, and you would have been provided it ahead of time. So let me share my screen and I'll show you where it is on the OAAS website. Okay, so we're on the page Building Community Leaders Information, ONCA Info. All right, so I'm going to take this and I'm going to put that link in the chat. All right, we're going to scroll down and we are going to go to the workbook. Okay, I'm going to click on the workbook. So the workbook opens up. And what you're going to see after you go to the table of contents, so starting on page 3, you start getting an order of steps, how to use this workbook. So once you've drafted your bylaws and constitutions, so then you've gone past through stages 1, 2, 4, and 5, you've gone through, 6, you've gone through. So the next step is you may choose to get legal review. That's up to you. But the next step is to follow the process outlined in your bylaws for how to actually change your bylaws. And if you don't have anything written in your bylaws about this topic, then what I'm about to go through is the standard procedure for approving changes to bylaws, including your constitution. So if your bylaws and constitution do not say anything, then go through the following steps. So number 1, your board votes on the changes. This would be like any other vote that you would take at a board meeting. You would want to, specify, put in writing the resolution, what you're being asked to vote on. For example, the board approves all changes to the bylaws and constitution as presented in, and you would give the document title so it's unambiguous. What exactly are the changes? If you say nothing in the resolution, then the changes to your bylaws are effective immediately. If you want, you can specify in the resolution that the changes will only take effect at some later date. For example, you can say they will only take effect after OMAFRA has approved changes to the articles, which you may choose to put in your constitution. Okay, that's a common example of something organizations choose to do, because often what's in the bylaws and what's in the articles or what you might put in your constitution, they depend on each other. So you don't want one to come into effect without the other. So it's common for the resolution to say the changes to the bylaws will only take effect after the changes in the constitution are approved by OMAFRA. Okay, so that's step 1, the board votes on it. There are 2 ways the board could vote on it. You could either vote on it at a meeting, and as I mentioned, it would be like any other vote. or you can pass a written resolution outside of a meeting. Now, this is something that is very common in the nonprofit sector. Often it's an email vote. Now, although it's a common practice, it's misunderstood. In order to take a vote outside of a meeting, it's not enough just to have a simple majority. You need to have a unanimous consent from all the directors who would be entitled to vote on it. Okay? So either way, you either pass it as a vote at a meeting or you pass it by um, uh, by a unanimous written resolution. Either way, once your board has approved it, the next step is to get it approved by the members. Now, there are two ways the members could approve it, either a unanimous written resolution, meaning all the members who are entitled to vote on it have to sign on to it, or through a members meeting. And then there are two kinds of members meetings you could have, either an annual members meeting, your AGM, or through a special members meeting. What makes it so special? You're calling it for this specific purpose. Okay. Which you choose to do will likely depend on, for example, timing. Can you have your AGM before October 19th, 2024? If so, does that leave you enough time? If your members reject or change your proposed changes, will that give you enough time to respond to that rejection or changes before October 19th, 2024? Right. So if the answer is no, you may choose to have a special members meeting ahead of time, or you may just choose that because it's more convenient. Either way, in order to have a proper members meeting, you need to send out proper notice to all your members, directors, and your auditor if you have an auditor. The notice needs to be sent out sufficiently in advance. If it's an annual general meeting, that's at least 14 days in advance and no more than 50 days in advance. If it's a special members meeting, then it's between 10 and 50 days in advance. The notice has to contain sufficient detail to allow your members to form a reasoned opinion on what you're asking them to vote on. So that might be the new version of the bylaws, that might be a summary of changes, that might be a document of track changes. It's really up to you. Anka doesn't go into detail, but I like to say, think about the person who is most likely to complain that they didn't get enough detail. How much detail does that person want? That's not a legal standard. That's just to avoid the meeting being taken up by an argument over how much detail was required. Okay, so you've sent out proper notice. Comes the actual meeting, you need to have a quorum. The default quorum for a members meeting is 50% plus one of your voting members. That's a default, okay? The quorum, just like a lot of what I've already described, can be changed by your bylaws or your constitution. So you may set a lower quorum, you may say 10%, or you may say 10 people. It's really up to you how you define your quorum. But you need a quorum to be at the members meeting, at least at the beginning. Once you have the quorum, then you can have a vote, and the vote to pass most changes to bylaws are a simple majority vote. And in the special case of ag and hort organizations, a simple majority, 50% plus one of the votes cast at the meeting, is also enough to make changes to your articles. And it's common for ag and hort organizations to put their articles in their constitution. Once the members have approved the changes to the bylaws, they are effective unless your resolution said otherwise. For example, if it delayed the time that it would be effective. But your articles, the changes that you may have put in your constitution, those aren't effective until you get them approved by OMAFRA. Either way, both your bylaws and your articles, if you are a registered charity, need to be submitted to the CRA. They don't approve it, but they want to have the changes on record. So that is a summary of what to do once you have drafted your bylaws and constitution. I see there is another question in the chat. Our current constitution has a big chunk of articles, 8 to 18, that appear as bylaws in the template. Would it be best to move all this material into our bylaws? So there are some things that Anka says needs to be articles. An example of this would be the number of directors, if you have multiple classes of members, if you have a dissolution clause, which is a rule that says what happens to your property after your organization is dissolved, if there are limitations to what your corporation can do. For example, if you say we never want to be able to sell a particular piece of land, those are all examples of things that Anka says needs to go in the articles. So those things could not be taken out of the articles and put in the bylaws. Other things, however, that you may have put in your articles, you can feel free to put in your bylaws. So, for example, some people choose to put, the board cannot receive remuneration. Some people choose to put that in their articles. That's something which Anka says can be put in the bylaws. So that could be moved out of articles and into your bylaws. So the short answer to your question is it depends what specifically is in your articles. It sounds like since you have a lot of things in your articles, probably at least some of those things could be moved to the bylaws. The difference between something being in the articles and something being in the bylaws is that for something to be in the articles, OMAFRA needs to approve it. Leonard, go ahead.
Yes, we call a special meeting to have the election to be accept this new constitution. And what if it needs to go to a following meeting? What is the process to call a second meeting? Is there still that 10 to 15 days wait to announce it all to all the members, or like how does that fall in place?
Great question. So if the second meeting is just a continuation of the first one, so let's say you didn't get through the entire agenda in the first one, people want to discuss more, whatever it is, then if the second meeting is just a continuation, Anka says you do not need to issue notice again. So you don't need to go through the whole 10 to 50 day notice period again. You can choose to if you want to, but you don't have to. As long as that follow-up meeting is within 30 days of the first meeting. You can even have multiple follow-up meetings, and as long as cumulatively all of those follow-up meetings are within 30 days of the first meeting, you don't need to issue notice again. It's enough to just tell the people at that first meeting when and where the next one is going to be. All right. Who's next?
I was just gonna say something about the articles. I believe there's a handful of things that the Ag and Hort asked for. You have to have the name of your Ag Society, the location. Actually, let me find.
Yes. So here, let's take a field trip to the Act. And horticultural. So I'll give you a complete list. So I just gave you some examples, but why not give you a more substantial list? All right, so here's the Agricultural and Horticultural Organizations Act. You can find it online. The first place always, if you're looking for something, is go to the table of contents. And here we see section 6, contents of the articles. So it has a specific list of things: the name of the organization, the type of the organization, the purposes, objects is another word for purposes of the organization, the place of the office, the name and addresses of the first directors. That's only relevant when you first become incorporated, the name and addresses of the members of the organization, and any other matter required under the Act or regulations to be set out in the articles. Okay. So this list would stack on top of the list from Anka. So Anka has a few other things like the number of directors, for example, if you have multiple classes of members, a dissolution clause, etc.
Just one quick thing. I had somebody the other night ask about the type of organization. You're an agricultural society. That's the type of organization. Someone had asked what that meant. So the OAS is an agricultural association. You're an agricultural society, and then there's horticultural society. So there's 3 types of, so that's what you would put in that.
Right, exactly. All right. Are there any other questions that people have?
I have a question.
Yes, go ahead.
Okay, in Section A, the sixth line says the name and address of members of the organization.
Mhm.
Of that, is that to be listed in your articles? Wouldn't that be changing annually or at election time? Do you
Uh,
state in your like the secretary has to keep a record of it? That's what they could read there, or
yeah, it's a great question. Um, Yeah, it's actually something I just noticed because it's different from what Anka requires, which is that a register of members be kept. Um, it would seem that you need to keep both because they don't conflict with each other. Um, would someone like to speak to what the common practice in the ag and hort orgs are, or what your organization currently does? Because you're right, Leonard. It does seem like that is the requirement that it would need to go in the articles, which seems pretty cumbersome.
because to me that's what the article could read, is that the secretary is required to have on file the name, because that's going to change at every elections or every year, new members and whatever.
Mhm.
So
We could speak with, I'm wondering if it's the same as the list of the original directors. It's only when they incorporate, you list the directors and the list of original members. We can
Yeah,
verify that with OMAFRA and see, because I know you
yeah.
have to submit information on your directors isn't it every year with, I don't know what goes in the TPOM, but I think it's a list of directors, but we'll verify that for sure with OMAFRA. I'm thinking maybe it was the original incorporation, but
So,
it's a good idea to check.
so I see the section 6 specifically refers to articles of incorporation. That was the confusion on my part. It is referring to the original members. The articles of incorporation do not get changed. If you make
okay,
changes to the articles, it's called articles of amendment. So that wouldn't go in the articles of incorporation. It would be a new document. So it does not mean that you have to change the list of members every time. The list of members goes into a register of members, which you are required to keep, but you don't have to put that in your articles.
okay. Because it
Other
doesn't
que
ask in the part where just the articles for the Act Society itself, like it doesn't list it that way.
exactly, exactly.
Okay.
And the other thing is that, your organization may have been incorporated before the Ag and Hort Act took effect. And in that case, you would not have a set of articles that looks like the articles of incorporation under this act. You would have an earlier document. So you may not have a document that sets out the list of all the members. You may have some other kind of unique document. You may not even have a document. There may have been some kind of statement that the government made to you, like in a letter or something like that, to recognize that you're incorporated. And from a legal standpoint, that original recognition would count as your articles. So it wouldn't have any of the types of information specified in section 6 because that section only came later. Other questions? Yes, Ellen, go ahead.
Yeah, yeah, in this big chunk of articles that we have, it seems to have so much information that's not included in the ONCA document. Like there's a list of all the officers that need to be on the board and the duties of the officers. It's all mainly stuff about meetings.
Yep. So there is nothing about meetings under ONCA that needs to be put in the articles, except for if you want to allow meetings to take place outside of Ontario, that would need to be specified in the articles. So if things are more granular than that, you're welcome to move it to the bylaws. ONCA does say that anything that you're allowed to put in your bylaws, you can also put in your articles. The difference between putting something in your bylaws versus articles is, number one, what I already said. It requires OMAFRA approval, so that makes it harder to change. So by putting it in your articles, you're kind of cementing it in your governance more. And number two, Onca actually says there are penalties for violating the articles. Now, I hope everyone's sitting down. The penalties are, in theory, up to $5,000 fines and up to 6 months in jail. Now, no one has ever gone to jail for violating Onca, that's for sure. And I've never found any cases of anyone going to jail for violating the Ontario Corporations Act, which is the predecessor and is a pretty old act. So these are on the books in theory, but it very rarely, if ever, happens. But with that being said, if an organization wants to have a rule carry more weight, you know, a rule to be able to say that you violated this rule, just so you know, there are serious penalties. So maybe you want to back down, right? If you want a certain rule to have more teeth, then one thing you can do is put it in the articles instead of the bylaws.
But if these articles were, I'm assuming, approved by OMAFRA at some point, then would it be more difficult for us to get rid of them and move them to bylaws now, or is
Correct. So in order to remove something from the articles, because that would entail changing the articles, you would need to get OMAFRA's approval to remove them.
Okay. Thank you.
My pleasure. Other questions? What can we include to avoid a meeting being hijacked, especially concerning sale of property? Well, firstly, I'm sorry if you're going through a difficult situation. You know, sometimes questions suggest that maybe there may be a difficult situation happening. Secondly, let's go through a few different things. So number one, ONCA does not set out a lot about meeting procedures. It's really up to each organization to set up its own meeting procedures. If an organization does not set out any details about meeting procedures in its bylaws or its constitution or in a policy book, then the kind of default position of the law is that the chair of the meeting decides. So that puts a lot of power into the hands of the chair. So the first thing is to just be aware of the power of the chair and be careful, be mindful about how you choose who is chair, so that picking somebody who is aware of their power, picking someone who is going to be respected by the individuals and knows how to chair a meeting in a forceful but respectful manner, if need be, can be very important. Okay, so that's not legally mandated. That's just sort of, practical kind of guidance about one way to prevent a meeting from being hijacked. Because the truth is, even if you have the best rules in the world, if the person who's actually chairing is not so strong, they don't consistently enforce them, then it doesn't actually matter. Except if in retrospect. So that's point number one. Point number two. In order to provide the chair guidance and a framework to be able to point to so people don't feel that chair is being, tyrannical, for example, then it is possible in bylaws or in policies to set out meeting procedures that you believe are appropriate and feasible for your organization. Many organizations choose to refer to an existing procedure, a set of procedures, for example, Robert's Rules. There are others out there if Robert's Rules doesn't work for you. So having that framework in place and making sure people are aware that that's the framework in place and that those will be the expectations can help set expectations for conduct at the meeting. Those are two layers of what can be done. Something I want to mention, however, this is a bit of the flip side. Members have a right to discuss anything that is relevant to the business of the nonprofit. So while, a person doesn't have a right to hijack a meeting in the sense that they just endlessly talk about it, a person cannot be denied the right to speak simply because, what they're saying may be controversial or unpleasant, or it may, stir up other people. If a lot of people want to speak, each of them individually has the right to speak. So it may end up having the effect of taking the meeting in another direction, and it may be that there's nothing you can do about that because, in fact, they do have the right to speak. but obviously setting clear parameters around how long each person speaks for, etc., so that the meeting can continue. Those are all powers that are the law has found to be within reason, within the purview of the chair. Do people on the call want to share what they've done in the chat as well to prevent meetings from being hijacked? It's always very helpful to hear from one's peers. The last thing I'll say is that another way to avoid a meeting being hijacked is to make sure the whole discussion doesn't just happen at the meeting, especially if you know ahead of time who is likely to potentially hijack a meeting, doing as much as possible ahead of time to bring them on side, to consult them, to create a process in which they feel they genuinely feel that they've been heard and taken account of, even if you don't agree with them at the end of the day. You may reasonably disagree, but nevertheless, the more you can do to kind of vet their concerns ahead of time, firstly, the less likely there is to actually be conflict at the meeting. And secondly, the more likely you are to be able to say, there's been opportunities to air these concerns. They've been addressed. Here's how they've been addressed. We don't need to revisit them at length here, etc. So all of that sets you up to be in a stronger position once you actually get into the meeting. Any other questions?
I actually have one. I think
Yeah.
we've discussed it before, but I'm not getting my head wrapped around it.
Mhm.
It's in Anka 54.1. It's under record date.
Mhm.
So I'm trying to, so it says the directors may fix the date as the record date for, and then there's several things in there. And it says a record date cannot be more than 50 days before the date of the event. One of the things that's in there is it being entitled to vote. So,
Mhm.
and I think we discussed this and I'm still trying to wrap my head around it. So some agricultural societies will have that members must be, say, a member for the previous year and that current year to be allowed to vote at a meeting.
Mhm.
The impression I'm getting from the record date is that would not be allowed per se, because you can only set that date 50 days in advance. Am I understanding that correctly?
That with the caveat that I can't comment on a specific provision in the governing document, and it does somewhat depend how it's drafted. The answer is yes. That if a membership class has the right to vote at a members meeting, then you cannot say that for more than 50 days in advance, that if a person became a member by that 50-day in advance cutoff, you cannot disqualify them from voting because of the date at which they became a member. Now, there are two caveats to this. Number one, if you have at least one class of members who has the right to vote, you can have a second or more classes of members whose right to vote is qualified in various ways. So a class of member, if there is a class of members who has a kind of unqualified right to vote, okay, let's call them full members, for example, then you can have, and that class of members, you can't set a record date more than 50 days. But the second class of members, it's not so much that you are setting a record date, but perhaps you're setting criteria around transferring between classes. So if the second class of member is a non-voting class, you say, well, you are you're a non-voting member for, let's say, a year. And then upon being a non-voting member for a year, if you're in good standing by the end of the year, you automatically transfer to be a full member. And at that point, you can vote. Okay, so that's a structure that requires you to have more than one class of members, but that's a structure by which it's possible to set to kind of create the effect of having a requirement of someone being a member for a certain period before they end up having the right to vote.
Okay, so I've got to, so what I want to do then is I want to get that down in writing so we can give some ideas if someone has that, because I know there are some egg societies that don't have a limit on it and
Mhm.
other egg societies that do. So some you can buy your membership up until the week before, and some would like to have it, you know, a year or have been a member the previous year, because it
Mhm.
makes sure that people that are voting on property or serious things
Yep, yep, yep.
understand the society. And
Mhm.
as this other one talks about hijacking, sometimes that was a concern why some of them put that in, that you had to have been a member for the previous year to vote so that people couldn't come in at the last minute and
Yeah, stacking the deck. Yeah,
Yeah.
it's an unfortunate reality sometimes.
so we can work around it, but that is what that means, is that if you don't have something in your bylaws to work around it, then that's what it means. You can only say people are a member for 50 days or have to have a membership 50 days in advance. Okay.
Yeah.
That was, so, okay, so we'll work on getting something in kind of worded into that then. Okay.
Yep.
So that's the 50 days is the default then? Or
That is, no, the default rule is that, so default rule means if you say nothing in your bylaws and constitution, the default is that if a person becomes a member even the day of the meeting, before the meeting, then they can vote at that meeting. That's the default.
that's the
If you,
default?
yeah,
Okay.
if you want to change that, then you can say in your bylaws or in your constitution that the only people eligible to vote are those who have been a member by X date, but X date can only be up to 50 days prior to the meeting.
And then, okay. So that would, and then if you want to have it, otherwise, then we have to put something else. So that was what I was
Yeah.
thinking, that the default was, yeah, so you technically you want to make sure you have something in there that stipulates and you up to 50 days, or otherwise the default is you can become a member the day before. So,
Yeah.
okay, we'll share that information. So that's what we've been trying to do with the workshop that we had last night, is make people aware of what's in there as defaults, be a little more, we've had the time to point out specific things, so they're aware of that they're in there, and, you know, do something if they don't like the default.
Other questions? Okay, I'm not hearing any other questions, so I'll go through um, some common questions that I've gotten over the years about Anka that I do as part of a frequently asked questions session that I sometimes deliver. So let me share my screen. Do. All right, so does Anka apply to us? Not an issue. We're all clear on that here. What rules apply during this 3-year transition period? So just a reminder, so we're in the 3-year transition period now from October 19th to October 2024. Right now, your governing documents apply even if they contradict Anka, as long as they were valid before Anka took effect. Okay, so you can rely on those governing documents now. Can we transition in parts? For example, could you approve some of your bylaws in one meeting and then change some other bylaws at a future meeting and so on? The answer is yes, but just be careful about this, because it may be that some of your rules depend on each other and you want to avoid unintended effects. Do we need to file our changed bylaws with the government? We talked about this. The answer is, if you are passing bylaws that change your articles, then that needs to be filed with OMAFRA. And if you're a registered charity, your bylaws and your articles need to be filed with OMAFRA, with the Canada Revenue Agency. Where can I find a lawyer to help with the process? So for this question, I'm going to go on another little field trip, this time to our website, nonprofitlaw.cleo.on.ca. So give me just a second, I'll share my screen here. Here you'll see under Legal Help Lawyer Directory, And one thing I'll also point out is we have a page on choosing a lawyer, which includes some sample questions that you might ask a lawyer to discern, you know, are they competent in the right areas and so on and so forth. We neither vet nor recommend anybody in particular, but we do confirm that some part of their practice includes nonprofits and or charities. What do we do if we don't have a physical address? So one of the new things under ONCA is that the government expects a physical address and not just a PO box. If anybody on this call is in a position where they only have a PO box or they don't have reliable mail to their physical address, then some of the workarounds include putting the personal address of one of the directors or officers. Number two, using some kind of shared mailbox service. Sometimes these are offered by community centers. Sometimes they're offered by hot desk services, that kind of thing. Number three, some organizations use the address of their lawyer and or accountant. What happens if we haven't been filing annual returns? This is not something that ag and hort organizations need to worry about as far as the Corporations Information Act goes. So you may have heard that certain things need to be filed on the Ontario Business Registry. Well, I have good news. That does not apply to ag and hort organizations. So you need to continue to make your annual filings with OMAFRA. And, you know, if you're out of date with those, then you have to deal with OMAFRA and getting those up to date. But you do not need to worry about making filings on the Ontario Business Registry. Could the ONCA transition process compromise our charitable status? The answer is it's unlikely. There's nothing under ONCA that would affect your charitable status in any way. However, as you go through the ONCA transition process, you may decide to change the language of your purposes. And if you're a registered charity, that could affect your charitable status. And I will add, though I don't want to scare anybody, but that's all, you know, always a counterproductive caveat because it scares people to begin with. When you update the CRA with your updated governing documents, so I don't know exactly what their equation is, but somebody will take a quick glance at your governing documents. So if they see any red flags in any of your kind of filings, they may look at your T3010, which is your annual information return with the CRA. If they see any red flags, then they may look into it. Now, that could be the case anyway. They may look into anyway. And certainly it's not because of the ONCA transition process. If they find any issues, it's likely they already existed. But that's something to be aware of. Some organizations need to grapple with, are there ducks we need to get in a row before we submit something to the CRA where somebody's going to look at documents we have submitted? What are the costs associated with the transition? So the answer is basically the costs are whatever you spend on advising. Unlike with regular nonprofits who have to pay $155 to file articles of amendment, you do not have that fee because you're not going through the Ontario Business Registry. You're just filing your bylaws with OMAFRA. So it's really just whatever you pay for advice. If you do get advice, the quotes I've been hearing lately are anywhere from a few $1,000s to $10,000. So it can be quite significant. How long does it take to transition? The estimates I've heard of the work involved in transitioning are 6 to 12 months. So certainly if you want to make that October 2024 deadline, then starting now is prudent at the very least. What if we don't have a letters patent? So we talked about this. So many ag and hort organizations may not have what they readily recognize as a letters patent. It's not necessarily a problem. The way to make changes is simply to pass bylaws and to file those bylaws with OMAFRA. And you could choose to put those bylaws in your constitution or not. Some organizations choose to put everything that would count as their articles in a document they call a constitution. But it's not required under ONCA or the Ag and Hort Act. Do we need to change our bylaws again if we recently changed them? So the answer may be yes. There have been changes to Onca even this past summer. So it's in that case, it was only to make it easier to have online meetings and so on. So even if you made changes before Onca took effect on October 19th, 2021, there may be some changes you still need to make. Where should we start the Onca transition process? The place I often point to help people start is simply by gathering all their documents, getting their records in order, which is always a good idea. You don't need to wait for Onca to get your records in order. I'm going to pause here to see, are there any questions about the Onca transition process or anything else that might have been sparked for you while I've been talking? Leonard, go ahead.
Just going back to the address, like you said, it could be your treasurer, your financial guidance. But like we host our fair, we have an agreement with the city for a 25-year lease for an arena. This could be our home address of the fair then.
Yes, any
Okay.
physical address. The way this address is used is this is the address the government will use to send you official documents, like notices. So it needs to, practically speaking, organizations will probably want to use an address where they are confident in the mail service so that they don't miss anything important from the government.
Okay. But they need a physical, because if we have a box number, but we also, there's no, that's all what we have is just a box number because we don't have any properties or nothing. So the box number could be the same, but the physical address could be the arena.
So the physical, so this is an interesting question. I actually don't know how this would work with OMAFRA, but with for regular nonprofits, the Ministry of Public and Business Service Delivery was not accepting addresses plus a PO box. It's a question for OMAFRA that
Okay.
I guess I will ask. Are they accepting addresses plus PO boxes? So let me make a note of that somewhere.
Okay.
Thank you for raising that.
Yeah. Well, MAFRA has a copy of our last constitution that was filed with them.
Mm-hmm.
Okay, because I know ours have been changed, but I don't know if it had been filed.
Mm-hmm. So they would not have, if an organization uses its constitution as the place where it puts all of its articles, then the answer is yes. If it was properly, if the proper procedure was followed, it would have been submitted to OMAFRA. If an organization does not use its constitution as the place where it puts its articles, then it wouldn't necessarily have been filed with OMAFRA. And if a correct procedure was not followed, it may not have been submitted to OMAFRA. So I cannot guarantee in your particular case whether they have a copy on file. But if, you know, if those caveats are met, then they would.
But they would have a file of the articles though, because we
That's
would have had
correct.
to, fill out the articles before getting anything started. Okay, thanks.
Okay, not seeing any other questions, so I'll go back to the PowerPoint. Maria, I see you unmuted. Do you have a question?
Yes, can you hear me?
Yes, I can.
This came up in the meeting last night. Let's say that a members meeting, they vote to cancel all fees to go to the fair.
Mm-hmm.
Well, that would possibly destroy the society, because they could go bankrupt doing that.
Mm-hmm.
Is there a provision that the directors can overrule a members meeting resolution?
So this isn't an issue dealt with explicitly in the ONCA, but I'll show you what the relevant provision is. So under ONCA, the Not-for-Profit Corporations Act, under the section Directors and Officers, so there's section 21. Subject to this act, the directors of a corporation shall manage or supervise the management of the activities and affairs of the corporation. So the responsibility and the legal power to manage the nonprofit is with the board. So questions that are considered management questions are within the power of the board. And there is mixed case law, mainly from for-profit companies, as to whether, in the case of for-profits, shareholders could pass resolutions that force management to do something that affects the management of the company. So you can imagine, for example, shareholders try to pass a resolution to get the management to divest from fossil fuels or something like that. So one of the legal strategies that management uses to push back against those resolutions is to say, how we source our energy or products is a management decision. The shareholders can't tell us what to do. Now, this is an evolving area of case law. It's pretty complex, and it's really it's a case-by-case determination, what falls into management, what doesn't. I couldn't opine on whether a cancellation of fees for the fair falls within management or not. That would unfortunately be legal advice, which falls outside of the scope of what I can provide. But that is the principle in general that would be used, is this management or not? I should also add that, generally speaking, when a board goes to a lawyer, let's say, because something happened at the members' meeting and has some kind of negative effect, and that somebody wants to prevent it from going forward, often the kind of arguments that are used are procedural in nature. The notice wasn't proper, the resolution wasn't proper, the vote wasn't counted proper, whatever it is. Often, resolutions that are ill-considered are challenged on procedural grounds as often as, if not more often than, the actual substance of the resolution.
Thank you.
My pleasure.
I think we had something in the Constitution document we were looking, or the bylaws last night, and I think it came from the OAS original governance documents, that it was a bylaw that the directors could I forget how it was worded, that if there was a resolution that was put forward by the membership, that they didn't have to abide by it if it was going to be detrimental to the organization. Now I'm trying to, I think it was in our Constitution. I thought I saw something in ANCA about that, though.
So the directors do have an obligation to pursue the best interest of the organization. With that being said, by the same token that the members cannot infringe on the scope of the director's duties. So, if something is considered management, then at least according to some case law, the members cannot pass binding resolutions that bind the board about management. The reverse is also true, which is the board cannot abrogate or limit things that fall within the members' powers, even if a bylaw has been passed. So I'll give you an example of this that I actually read this morning. I'll see if I can find it. Let's see, Charity Law Association. There's a practice that comes up often when an organization is subject to an umbrella organization, or it's a chapter of a local organization, and there's a regulating body, something like that. In those cases, then sometimes what happens is the charity will put in its articles that in certain cases, the umbrella organization actually has a veto power. And so it's a legal question. Can an organization give veto power to another organization in its articles without there being some other kind of contractual agreement? And the government of Ontario sent a letter to the particular lawyer whose blog I was reading, which is Mark Bloomberg, the government of Ontario sent him their view that such articles could not infringe on the powers of the members. So you can't have something in your articles that say that members, for example, don't have the power to elect the board or remove directors. They do have the power to elect the board. They do have the power to remove the board. You can't take that away from them. So and that's if it's in the interest of the organization or even if it's against the interest of the organization. So those types of things cannot be taken away from the members.
Okay, so we'll have to look at that one section. It'll be interesting once ours come back to see what if they've changed something in ours, in the OAS one, to say whether or not that's.
Okay, not seeing any other questions, so I'll go back into the PowerPoint. So two questions I often get about members' meetings. One, are online meetings allowed under ONCA? And the answer is yes, by default they're allowed. So if you want to limit this, or if you want to say online meetings will only be allowed under certain circumstances, then you have to say that actively in your bylaws or your articles. When do AGMs need to happen? AGMs need to happen within 15 months of the last AGM, and within 6 months of the end of the last fiscal year. Whichever one of those is earlier. Before we go to governance structure, does anyone have any questions about members' meetings?
Yeah,
Yes.
Going back to the members' meetings or the annual meetings, it says to state the location of the meeting. Can the bylaw state that the location and the date and time will be posted in the notification? Because the meeting is not always at the same place either, the annual meeting.
Yes. So the bylaws can say that the meeting, the members' meeting will take place at a location and a place and a time to be determined by the board. That's fine. And in fact, if your bylaws say nothing, then the default is that it will take place at a place and a time determined by the board.
Okay.
And I would also add that your notice of members' meetings, if you are having a completely online meeting, it doesn't need to state an address, but it would need to provide either a link or a means of how to register, some way of how somebody could participate in that online meeting. Or if it's a phone meeting, a telephone number, a teleconference number, that kind of thing. Okay, governance structure. Excuse me. Do directors have to be members? The answer is no. There's no requirement for directors to be members. So if you want to require that directors be members, you have to say that explicitly in your bylaws and or your constitution. Do we need to have members? The answer is yes. And in fact, in the case of agricultural and horticultural organizations, the Ag and Hort Act actually says your membership needs to be open to anybody who pays a fee. So you can choose to have multiple classes of members and make one of those other classes the voting membership, so that anyone who pays a fee is only entitled to be a non-voting member, but you do have to have membership open to anybody who pays a fee. Are all members entitled to vote? The answer is no. Specifically in the case of Ag and Hort organizations, you're actually not allowed to let members who are under 18 vote. This is unique to Ag and Hort organizations because other nonprofits can have people of all ages vote. Additionally, you can also have multiple membership classes, some of whom may have the power to vote, others may not have the power to vote. Do we have to have a chair? Yes. So when it comes to what officer positions you're required to have a chair, and you're required to have a treasurer or secretary treasurer. Does the board have the power to remove a director? The board does not have the power to remove a director, at least not directly. No pun intended. The only people who have the power to remove a director are the members. The members have the power to remove a director with a 50% plus one majority vote at a members meeting. Now, the board can indirectly remove a director in any of the following three ways that we discussed at the Bring Your Own Bylaws sessions previously. Number one, if a director is required to be a member, then if the person is removed as a member, then they automatically stop qualifying as a director. Number two, bylaws can have what are called deemed resignation provisions. Provisions that say if the director does X, it will be considered as if they resigned. So once they've done X, it's not that you're kicking them out, it's that they, by their own conduct, signaled they've resigned, and then they stop being a director. Or number three, you can build in qualifications to who is a director. For example, has never been convicted of a crime, such that if they fail to meet those qualifications, if one day they're convicted of a crime, it's not that you kick them out because they're convicted of a crime, it's that they stop qualifying. So they stop being a director. Go ahead, Murray.
Going back to, do we have to have a chair?
Mm-hmm.
I take it the chair and the president can be the same person.
That's correct.
So we need to make sure that it's always chair/president, because we only have a president. We've never had a chair.
Yeah, it's probably chair, president, and that sounds like, dancing on the head of a pin. But the legal requirement is that someone has the title chair. Chair/president implies that it's one title. Whereas chair, president could be that they have two titles. It could also be president, chair. The point is simply that somebody has to have the title chair.
Got it. Thanks.
My pleasure. Continuing down the list, how long are directors allowed to serve? So there are two kinds of directors that a nonprofit can have, an ag and hort organization can have. You can have directors who are elected. Okay, that's the default kind of director. And if you allow for it in your bylaws and constitution, you can have what are called ex officio directors, people who are automatically a director because of some office they hold. Now, an ex officio director is a director as long as they hold that underlying office. So, for example, if your bylaws state that the counselor for your area is automatically on the board, then okay, then they are on the board as long as they are a counselor. You don't have to have an election. You don't have to renew their directorship. As long as they're a counselor, they're on the board. If you want to take them off, you would need to take out that provision from your bylaws, your articles, or you would have to remove them as counselor. So that's one kind of director. The other kind of director, so elected directors, can only serve up to terms of 4 years. They can serve as many terms as they want, unless you limit this in your bylaws or your constitution, but they need to at least have an election at least every 4 years. Now, your bylaws or constitution could provide for a shorter term. You could say 1 year, 2 years, 3 years, that's up to you. But you cannot provide for a term longer than 4 years. Murray, go ahead.
Do the ex officio directors have to have a vote, or can you restrict them from having a vote?
So this isn't something dealt with in the Act explicitly. However, the common view in the sector, and I think in the legal community, is that it's possible to make somebody a non-voting director on the board of a nonprofit. A few things about non-voting directors. So firstly, an ex officio director is not automatically a non-voting director. Automatically, they're like any other director and they have the power to vote. So if you want them to their right to vote to be limited, this is something you would need to put in your bylaws or your or your articles. Number two, a non-voting director has all the same obligations as a voting director. So if you have let's say an ex officio director position that's really more honorary than anything else, let's say a founder or a lifetime member or something has an ex officio position, it's important, I think, that you're aware, that they're aware, that in addition to the gift of this honor, you're giving them the gift of liability as well, which maybe they don't want. With that being said, and this is the third point about ex officio directors, although they cannot vote, they do have the right to signal their dissent to decisions being made. And they have the right to demand that these be noted in the minutes of a board meeting. This is important because it may protect them from liability if that decision is found to there to be a conflict of interest, or it to be negligent in some way. So this is something that you may want to inform your non-voting directors of, as well as your voting directors, that they have this right to dissent, and that if they don't dissent and they're in attendance at the meeting, and in some cases, even if they're not in attendance at the meeting, it will be assumed that they agree with what's being passed. So they need to actively dissent, and they need to actively request that it be recorded in the minutes if they want it to be recorded in the minutes. Are articles, bylaws, constitutions, and policies the same? So they are not the same. We've talked a lot about this at past sessions, but just to revisit. So articles, the first articles, the articles of incorporation, are created by the government and sent to an organization. When it first becomes incorporated. In the case of Ag and Hort organizations, it says you can pass bylaws that are then approved by OMAFRA to make them articles. To have the status of articles. So it may not be a separate document. It may be embedded within your bylaws and your constitution, but the difference is it's been approved by OMAFRA. Bylaws are a document that for sure you created yourself. It would contain your rules of governance. The word constitution is sometimes used interchangeably with bylaws. It's sometimes a separate document. The key thing to ask is, does our constitution contain the kind of provisions that are required to go in the articles rather than the bylaws? And do we follow the same procedure to approve the constitution as the bylaws? If we follow the same procedure, meaning the board votes and the members vote, it's likely it's going to be treated the same as the bylaws. If we follow an additional step, submitting the constitution to OMAFRA, that may imply that it's being treated as the articles. If we don't follow any of those steps, that may imply that our constitution is being treated more as a policy document than as the bylaws, and would not have the same force and effect as bylaws. And then there are policies, and policies may go by many names. You could have a code of conduct, you could have a procedural document, you could have a handbook, and organizations are welcome to create all kinds of things. That's really up to you. If ONCA or the Ag and Hort Act says that something needs to be in the bylaws or the articles, it wouldn't be enough to put that rule in a policy unless you refer to that policy in your bylaws or your articles. Murray, go ahead.
I want to just go back to the ex officio directors. Right now, our articles say that there may be two ex officio directors representing the township. Nowhere do we say that they are voting or non-voting. Does that imply they are voting?
So without commenting on your particular provision, the default is if someone is a director, they have the power to vote.
Got it.
All right, before I continue, are there any other questions? You can either put them in the chat or raise your hand as you feel comfortable. Okay. Going back into the PowerPoint. Records and minutes. So what does ONCA have to say about the records and minutes we're required to keep? So number one, and I hope everybody's sitting down because this can sometimes surprise people when they first hear it. How many years of minutes do we need to keep? The answer is
Forever.
all of them. Yeah, forever, yes. Now, if your organization has been around for 140 years, as I've sometimes encountered, or fewer than that, 50 years, 30 years, whatever it is, and you're missing minutes, firstly, don't worry. It happens to almost everyone I've met. And secondly, it's the law cannot require of you the impossible. If there is no way to reconstruct the minutes, there's no way to reconstruct the minutes. So the question is, what could happen and what could you do about it? So if an organization is lacking minutes, two things might happen. So number one, if a legal issue comes up from that time period, and it may be there's such a thing as a statute of limitations, which limits how long ago somebody could bring a legal action from. So if it's far in the past, the likelihood that the statute of limitations has elapsed significantly goes up. But let's say there's some kind of legal action that could still be brought. The effect of lacking minutes just means that that's one piece of evidence you can't rely on to defend yourself. So what might the minutes have contained? They might have proven that the board did its due diligence, that such and such was said, or such and such was considered, or advice was sought, and so on and so forth. By the way, in order for minutes to serve this function as evidence that you might want to rely on in the future, they need to be kept well. If you have minutes that are, barely contain any detail, they may not be worth the paper they're printed on when it comes to using them as evidence in the future. So this is one more reason to keep good minutes that contain, useful information. However, not having that particular piece of evidence to rely on is not the end of the world if you have other evidence to rely on. So it's unfortunate maybe if that would have been good evidence, but it's not the end of the world. The second way that a lack of minutes may come up is, especially if you're a registered charity, if you're being audited. The Income Tax Act has certain requirements of when an organization is required to keep records. So it's at least going 7 years back. And the CRA has certain policy positions about when registered charities are required to keep records. And in fact, for their policy expectations, there is no end date going back. Whatever audit period they might look at, and charities do not have the same audit limitations that other taxpayers do. The mere fact that records are missing could in itself be a problem. So the practical implication of this is that for sure the previous 7 years, it is important to have complete records, anything that might be relevant to a CRA audit, and certainly minutes of meetings would fall into that category. So perhaps it's worth going to the time and effort to try to reconstruct some minutes, at least rudimentarily. But it's a cost benefits analysis in practice, although to be clear, ONCA does require that all the minutes be kept. Okay, number 2. What does ONCA say about in-camera minutes? So just to clarify, in-camera minutes are minutes from a meeting or from a section of a meeting where some kind of sensitive, confidential topic is under discussion. So, but you want to have a record of it. And often when you're dealing with sensitive, confidential things, you do want to have a record of it. So these minutes are kept separate from the other minutes. Now, ONCA doesn't say anything about in-camera minutes directly. The Ag and Hort Act doesn't say anything about in-camera minutes directly. What it does say is that in terms of who's entitled to access board minutes, it's only 3 groups of people: the board, the auditor, if you appoint an auditor or financial reviewer, and certain government-appointed officials, such as court-appointed investigators, CRA auditors, etc. Okay. That's a limited group. The members do not have a right to access the board meeting minutes. Members of the public do not have a right to access the board meeting minutes. Your bylaws or policies may say that they have a right to do so, in which case it may be relevant for you to distinguish between general minutes, which they have a right to access, and in-camera minutes, which you may carve out and say they don't have a right to access these. In any case, while I can't give you advice specific to your organization, in general, it's a good idea if an organization does allow the public to access its board minutes to have some kind of mechanism to allow for confidential discussions that are not accessible by the public, because sometimes boards do handle information which under employment law or under privacy law or simply for strategic or reputational reasons, the board has a legitimate interest in the broader public not access to. In any case, there are often competing values between, on the one hand, transparency, which is an important value, and on the other hand, being able to have free and open discussions and protecting people's privacy. So each organization needs to decide for itself how to strike the right balance between those competing values. When do we need to start keeping directors' consents from? So ONCA requires that when a person becomes an elected director, they sign a consent form saying, I agree to be a director of the organization. Here's the start date. Here's my address where you can send me documents. Here's my signature. Technically, this requirement goes back to October 19th, 2021. If you have missed that, you haven't been doing that, it's not the end of the world. ONCA says that as long as you get the consent, it works retroactively. What can we do if our members don't want their information shared with other members? So under ONCA, an organization is required to keep a members list, including the names of members, the start date, the end date of if somebody stopped being a member, the address for service, which is the address where that member agrees to receive official documents. It doesn't need to be their personal address. It could even be the address of the nonprofit. It's just the address where they're going to get notices of meetings and so on and so forth. And then if they agree to receive documents electronically, their email address as well. And if you have multiple types of members, what kind of member they are. You can add to what details would be kept on the members register, but those are the essential items. That list needs to be kept going back 6 years. Now, ONCA says that if a member requests a copy of that list and they sign an agreement saying, I'm only going to use it for allowed purposes under the Act, which basically those purposes are things related to the business of the nonprofit, then they are entitled to get a copy of that list unless the organization or an interested party goes to court and explains to the court why they shouldn't have to give up the list. Obviously, this raises some privacy concerns, and this may be something which you want to make members aware of at the time they become members, that their information, that a nonprofit may be compelled to share their information under these circumstances. So that's something you may wish to be transparent about. Now, as I mentioned, if you don't want to share that information, you need to have a specific concern, a specific reason that you can give to the court as to why you shouldn't have to. It's not enough to just say, in general, people are concerned about their privacy. There needs to be, for example, a specific threat to safety. So I'm going to pause here and see, are there any questions about any of those topics or anything we've discussed thus far? Okay. Not hearing or seeing any questions. So I'll jump back into the PowerPoint. Finances. So was an audit always required? And the answer, especially for Ag and Hort organizations, is yes. Up until recently, an audit was in fact required. Changes were recently made to the Ag and Hort Act, which will make an audit no longer required and will replace it with a report that OMAFRA will specify what needs to go into this financial report. That requirement to give a financial report to OMAFRA replaces the requirement to get an audit or a financial review under ONCA. So ag and hort organizations can ignore the requirements for financial review under ONCA. So there you may have read or seen or heard online, all these rules about if your annual revenue is under 100,000 or under 500,000, you can waive an audit this way or that way. None of that applies to ag and hort organizations anymore. The only thing you need to concern yourself with is that financial report to OMAFRA. With that being said, ag and hort organizations, just like regular nonprofits, do need to provide financial statements to their members. So that has not changed. Number 2, does X agreement make us a public benefit corporation? So there are 2 kinds of organizations under ONCA. One is what you might call a regular nonprofit, and then another status is a public benefit corporation. Public benefit corporations include charities. So if you're a charity, you're automatically a public benefit corporation. So that's not complicated if you're a charity. If you're not a charity, but last year you received more than $10,000 in basically public funds, either funds from government, federal, provincial, municipal government, or an agency of government, or in gifts or donations from people who are not your members, employees, directors, or officers. So if you received more than $10,000 last year from any of the sources I just mentioned, this year you're a public benefit corporation. You would do the same calculation next year and the year after and the year after. So it's a year-to-year determination. If you're a charity, it's simple. You're a public benefit corporation. If you're not a charity, you have to do this year-to-year determination. So if you're a public benefit corporation, there are certain additional rules that apply to you, like you're limited in who you can give your property to if you dissolve, for example, that you only up to 1/3 of your directors can be employees, etc. So the question might come up, does getting funding in the following way count towards our status as a public benefit corporation? And the most common version of this question I get is, do sponsorships count towards public benefit corporation status? And the answer is, it depends on how that sponsorship is structured. Sponsorship is not a legally defined term for our purposes. A sponsorship may be one of 2 things. Either A, it may be a gift that somebody just gives you and they expect, you to show your gratitude. So you mention them, let's say at the fair. Okay. So if that's the case, if it's just a gift where you express gratitude at some point, then that's a gift and it does count towards your status as a public benefit corporation if the person who gave the gift or if the organization who gave the gift is not a member, officer, employee, or director. If, on the other hand, the sponsorship is an exchange, we will give you $10,000 if you give us XYZ advertising opportunities or speaking opportunities, social media opportunities, whatever it is. In that case, you're effectively selling advertising. That's what you're doing. So that's not a gift. That's not a grant. That's not a donation. That's you're selling something. That's an exchange. So that kind of sponsorship would not count towards your status as a public benefit corporation. Yes, go ahead.
As far as the public benefit corporation and dispersing your funds if you dissolve, does ONCA not, or does the Ag and Hort not overrule that if you're not a charity? Because the Ag and Hort stipulates that the trustees of that the directors who will then be trustees are free to distribute the funds when the Ag Society dissolves. So then it shouldn't make a difference if they're a public benefit corporation?
So it's an interesting question. The analysis that I'm working with is that the discretion of the trustee, because ONCA actually has similar wording in that the trustees have the discretion to distribute the property. but that discretion may be subject to resolutions passed by the members. It may be subject to statutory parameters around, how the trustees can distribute them. So my understanding is that the Ag and Hort Act and ONCA actually don't conflict on this point. The discretion of the trustees are just qualified by the provisions set out in ONCA. Now, you're right to say it's a question. It's not obvious. Maybe somebody could take the position that the Ag and Hort Act gives unfettered discretion to the trustees, not qualified by ONCA, that it actually overrides ONCA. If this becomes a concern, I would seek legal advice. But from my view, they work together.
Okay, because I was kind of thinking that it would overrule it, but they actually work together then.
And again, this may be an area that requires some specific legal advice, but let's go to the wording of the act to see more specifically what we're talking about. So
It would be dissolution, yeah, so
probably
there would,
under general dissolution.
yeah, so probably possibly under 20 trustees.
Yeah. Okay, if an organization is dissolved by the minister, the persons comprising the board at the date of dissolution are the trustees of the assets of the organization and shall deliver to the director a statement of the assets and liabilities of the organization. The director may direct the trustees to pay the debts of the organization and liquidate all the assets for such purposes. Subject to the approval of the director, all money and assets remaining after the payment of debts shall be disposed of by the trustees in such manner as they may determine. Yeah, it's a good question. I may need to revisit this.
It's been interesting, hasn't it?
Yes, it has. Yeah. Yeah, and so I hope one thing people take from the call, and I've pointed this out before in some of our sessions, it's a learning process, and it's a learning process for lawyers too. So, I'm included in this. Don't assume just because somebody's a lawyer, that what they say is necessarily, the golden truth. It's very helpful to have some pushback every now and again to force us to reconsider some things.
Well, I'm not sure that OMAFA fully understands their legislation to staff that are people years ago maybe, but I'm not sure that all of them do there now either. So it's, yeah, trying to get any information out of them is difficult as well.
Yeah. Are there any other questions about finances under under Ag and Hort Act and or ONCA? Murray, go ahead.
I printed off the financial review certificate that's on the one of the websites. It must have been on the Minister of Agriculture, Food and Rural Affairs.
Yep.
And this is what you can use instead of an audit, I take it.
Yeah, that's correct. That they're going to have their own financial review process.
That's my understanding, that when they put that in there as a financial requirement, it's what's listed in the form on TPON. So you're allowed to do an audit, you're allowed to do a review engagement, you're allowed to do, there's another term that you can select 2 people to do a review of the books, but you can't use a reader review. That's, I think it specifically says in the TPON, you can't use that. So that's because the Ag and Hort specifically mentioned audit, so we asked them to put something else in there. So it allows whatever TPON asked for, which is one of those 3 options.
Is there any requirement for the reviewer? Because in one place it says volunteer reviewers must not currently be on the executive of the board,
Yeah, so
be on the executive or the board. But then in another place, it talks about um, audit review report, not a compilation. I'm not sure what that is. Also known as notice to reader, that has been completed by a professional firm individual and CA, CMA, CPA, CGA. So
So the
if we
notice to
do a
reader,
financial review,
the one that was called a notice to reader is not allowed. There was, what was the term you said before that? Financial review, because you're allowed
compilation.
a compilation. Yeah.
compilation.
That's not allowed. They've had that in there. So it's an audit, a review engagement, or you can appoint two people who are not on the executive. They stipulate in there the two people that can do the review and put some different points in there. I think they can't be related to the treasurer, et cetera, the people, and they have to be appointed at the annual meeting, I believe.
So my
Right,
understanding,
but do they need any professional qualifications other
So-
than being a volunteer?
so until recently, my understanding is the situation has been the following. The Act said you needed to get an audit, and that definitely has very specific requirements about who needs to do it. They need to be a CPA, they need to be independent. There are all kinds of specific rules about what it means to do an audit. However, OMAFRA's policy position was that exactly what you just described, a much more specific financial review with a lot more flexibility, met OMAFRA's expectations, and then they would approve it on a year-to-year basis. And what was a requirement was basically a function of whatever they said in their policy documents, such as the requirements you just read. Now, with regards to what the law is going to be going forward, so I mentioned there was a change in the Act recently, and the change said we no longer require an audit, so strike that out and put in something, words to the effect of a financial report, the details of which are to be specified in regulations. Now, from what I've seen thus far, the regulations have not yet been published. Right. So this change has not yet come into effect. So in theory, an audit is still required, but it would change any day. And practically speaking, OMAFRA's position has long been this, financial review approach. Once the change comes into effect, there are also going to be regulations. Those regulations will be what defines the parameters of that financial review. That will be the place to look to see what are the requirements of who carries out the financial review. I would expect, but I don't know, I haven't seen draft versions of these things or anything like that. I would expect that there would be some kind of criteria around who carries out the financial review, because that's quite typical of these kinds of requirements.
Got it.
Any other questions about finances under ONCA or the Ag and Hort Act or anything else we've discussed to this point? All right. Not seeing or hearing any questions, so I'll jump back into the PowerPoint. All right, so a few discussion questions for you. This is actually towards the end of the PowerPoint. Do these questions resonate with what you're hearing? So in terms of the ONCA transition process you've gone through so far, have any of these questions come up? And are there any frequently asked questions you think I'm missing that should be included in this discussion? So this is really an opportunity again for you to share any any questions that have been coming up as part of your ONCA transition process.
I do have one.
Go ahead.
Under objects or purpose, some of the things that are listed really don't apply to what we do. Like researching the needs of the agricultural community and developing programs to meet those needs. We don't do that. So I know it states that it should be in there, or you don't have to put it in there. Does it really matter whether it's there?
So two points without getting to the specifics of that particular line. So number one, looking at the Ag and Hort Act, let me just jump in to here. So the Ag and Hort Act does include some details about the objects of agricultural associations, agricultural societies, and horticultural societies. So let's look at each of those objects in turn. So the objects of an agricultural society are, and then it specifies these. So if you're an agricultural society, these are your objects. Regardless of what you say, these are your objects. You can maybe add to them, but you're definitely going to have these two objects.
Well,
to promote
that
development.
was associations.
Oh, sorry, agricultural association. Yeah, my apologies. Thank you for that clarification. You are for sure going to have to promote the development, sale, and export of agricultural products, to provide educational opportunities related to an agricultural.
Well, I think you're in the wrong section though.
I'm
Aren't
going
we-
I'm going systematically through all of them.
Okay.
Yeah, sorry about that. It's in order to provide the most comprehensive kind of information, rather than specifically address the line you're talking about. So if there is an object that is set out in the act, regardless of whether you provide it in your governing documents or not, it applies to you. But let's say you are an agricultural society. The objects of an agricultural society are to encourage an awareness of agriculture, to promote improvements, quality of life of persons living in the agricultural community by. And so here again, it sets out mandatory objects, meaning these objects apply to the agricultural society, regardless of what you say in your governing documents. So this includes researching the needs of the agricultural community and developing programs to meet those needs. It applies regardless. So for taking it out of the governing documents, if an organization qualifies as an agricultural society, would not have the effect of taking it out of the purposes of the organization, for example. And the same thing is true, just to round it all out, for horticultural societies. The objects of a horticultural society are to encourage interest, improvement in agriculture. And then here it doesn't even say by. It specifies by in each of the lists. By holding meetings, by encouraging planting of trees, by promoting balcony, etc. So at a simple level, the short answer is you can't really take it out. Even if you did take it out, it wouldn't have the effect of taking it out. But more specifically, what is to your question, does it matter? What is the effect of having a purpose that is not something you actively pursue? The answer is it doesn't really matter. You can have a purpose that you do not actively pursue. You're not required to actively pursue all the purposes you have on file.
There's actually something, a phrase that's on our website that OMAFRA provided a number of years ago, and basically that's what it says. You may not follow all of them, but you're supposed to be following the gist of most of them. You go to our website, and when you go to the page about us and go to the page that's titled Agriculture and Horticulture Organizations Act, there's a blurb in there where they talk about the objects, and that you may not, each society may not fulfill every object, but that's okay, basically.
And that was why I was asking the question of whether we could take it out, Because that sort of implies that you can take it out.
So taking it out would have no legal effect.
Got it.
And it would be interesting if OMAFRA approved taking it out because it would contradict the act. So really, if they know what they're doing, I mean, I don't think it would make sense for them to approve taking it out. Again, maybe that's weighing into legal advice. I don't know, but it would be surprising.
So it's Mike Dupuy here speaking.
Yeah.
Just to maybe help Murray, maybe so I can understand the same thing. So like when you had up on the screen there, those A, B, C, D, E, and F. So F says conducting or promoting horse races when authorized to do so by a bylaw of the society. We don't actively do that, but there's nothing wrong with leaving it in. Or we could take it out, but does that, like that would be, you're saying we may as well leave it in there even though we don't pursue it.
That's correct.
Yeah.
And I'd be surprised if you could take it out, because to take it out, you would need to get OMAFRA's approval, and OMAFRA would look and say, well, it looks like you're deviating from the definition under the act. I don't know if that has legal effect or if it, disqualifies you as an organization. But as long as you're an agricultural society, the act says what your purposes are.
That sounds good to me, but OLG is going to get their fists in there anyway to get the money if you do have horse races.
Right.
Yeah. If it comes to like we host also a farmer's market, do we need to just keep the policy procedures of how it's going to be run, or it should be in the articles or just in the bylaws?
So, generally speaking, more operational type information is put in policies. Every organization has the discretion to do what it thinks is best. You can put it in the bylaws if you want. For example, if there are certain rules you really want to make sure get respected. For example, the farmers at the farmers market have to be local, defined by X, geography, and that's so important to you. You want to bake that into your constitution. You can do that. You have that option, but if it's a lot of details of how many stands you can have, how much people have to pay, how much they can sell, etc., then generally speaking, that level of detail does not does not go in bylaws or constitution. So you would generally put that in a policy.
Okay.
Bev, last night would this be the proper time to ask about that record date or date of record or something?
Bev, you're on mute.
We had discussed that earlier, so we
Oh,
will
sorry.
have some information about that. So I'm gonna look at that and then I'll send out some information on that. But basically what we were thinking is, yes, you can only, the way it stands is it's 50 days maximum. If you don't put something in your bylaws, then it can be as of, the default is basically the day before your meeting that someone would become a member. Did I paraphrase that correctly?
That's right. So that, yeah, the default is if they become a member the day of, before the meeting, they can vote at the meeting. If you want to put it in your bylaws, you can say up to 50 days before. If you want to make it longer, there are workarounds. For example, you can have multiple classes of members, some of which are non-voting, and you could say that after a certain period of time in the non-voting class, somebody transfers over to the voting class, and that is allowed. And it's up to you to determine, how long does someone need to spend in the non-voting class before they transfer into the voting class. There may be other workarounds as well. Again, I'm not here to advise on a particular course of conduct. I'm just flagging that the record date does apply in terms of it limiting how far in advance you can require that somebody be a member before they have the right to vote in a voting class of members.
Thank you.
Murray, go ahead.
In the act, there's a clause about, it says, a society that expends any of its funds in a manner inconsistent with the objects set out in Article 3, subsection 1, may result in a forfeit of all claims to participate in any legislative grant.
Mhm.
My question is, should that be with Article 3, or should that be somewhere else in the document?
So this is a great question because, you know, it's an occasion to take a step back and think more broadly about how we draft our governing documents. And I'll actually go to LinkedIn and get a link of an article I wrote on this topic some time ago. But the short answer is it's entirely up to you what order you put your provisions in your governing documents. The perspective I always encourage nonprofits to take is think of your reader. You know, how familiar are they going to be with the document as a whole? How easy is it going to be for them to navigate the document? What information don't you want them to miss? You know, is there a clear table of contents? All these kinds of questions help you to determine whether it makes sense to put a particular provision, you know, at the front of the bylaw, the bylaws or the Constitution or the articles, or at the back or in the middle, how to number it, you know, whether you use Roman numerals or regular Arabic numerals, or you know, what is up to you. Here's the article, and you'll see there are various practices. I'll share my screen. There are various practices that I've actually user tested with people giving them tasks to see, you know, here's the situation. What is the rule in your bylaws? And I actually watch them and I ask them for their thought process. I see how long it takes them and whether they get it right or wrong to see whether different designs of bylaws help or hinder them finding the answer. So firstly, you know, having realistic bylaws, that goes more to the substance. Thirdly, they're easy to navigate, and this links to another article where I talk about having table of contents, ensuring there are page numbers, having clear headings, making sure the headings are in active voice. They're not just generic words, such as, you know, sometimes we have a section called general. That's not a helpful section title. Making sure there's lots of white space on the page so it isn't very intimidating to read or it isn't very dense. Making sure the subsections are very short. These are all examples of practices that make a document more readable. And then there's different practices here about writing in a plain language way using an active voice. In the governing documents, so our website has a bylaw builder that creates a set of bylaws not specific to the Ag and Hort Act, so I wouldn't necessarily recommend you use it. Thankfully, OAAS has a template that's more tailored to Ag and Hort organizations. But if you do experiment with the bylaw builder, you will see that the actual structure of the bylaws is to have titles in the form of questions and the sections in the form of answers. And we did this for two reasons. Number one, the Q&A format makes it more encouraging to use the bylaws as a kind of frequently asked questions, as a resource document to help you. And number two, the questions, the question format titles are truer to what you might have on your mind when you actually turn to the bylaws looking for an answer. So it's easier to find an answer if you're literally searching with a question on your mind and you see in the titles, oh, this is the question I had. And then finally, keep in mind not just who the readers are going to be, but think about who the most junior reader is going to be, the one with the least knowledge. That's the person to which it needs to be most understandable to, not the person who's the most experienced and has all the institutional knowledge. Imagine 10 years down the road, 20 years down the road, when you're not around anymore, are these governing documents going to be intelligible? Are people going to be able to understand them? So thank you for that question. That's a long-winded way of saying it could be Article 3, it could be 5, it could be 1. It really depends. All right, I'm not seeing any other questions, and I've gone through my kind of preset common questions. So I'm happy to stay on the call until 9. You have me until 9, but Bev, back to you in case you have any parting words.
Not really. Thank you very much. As always, every time I listen to you, I learn something new or pick something new up. So I know I have to go back and look at our templates again. I'm always tweaking them, so I will go in and look at a couple of things. Is nobody else has any questions or comments? We'll do this again in a month. There's another template, a webinar next Wednesday. If anybody wants to come, we go through I created a document that kind of has a list of ones to watch for that are mandatory bylaws, ones that are default bylaws. Basically what you've done in your workbook, only I've picked out a few more of them so people kind of, oh, I should go check that out. Is it, does it refer to us, and maybe do we need to do something with it? So any other questions from anybody?
This session tonight has been recorded. It'll be posted on the webpage.
Yes, I think so. It's been recorded. I think
Yeah.
he's posting it. I'm not positive. I'll let Vince decide what he's doing with it.
Because it's good to go back and listen to it again, because there's so much information coming through. It's and I know the head count was a bit lower tonight, but we've been having a lot of meetings following, so it's hard for everybody to attend. So if it is recorded, then everybody have access to go back and have the opportunity to listen to it. Yep.
For sure.
We've had a lot of people take part in all the seminars and webinars. Like, it's been pretty amazing. I forget what Vince had for numbers, like what percentage of the ag societies and how many members we've had turn out to all the different ones. So, well, if that's everything, thank you very, very much again, Benjamin, for all your information.
My pleasure.
We will talk to everybody or Vince will talk to everybody at the next one. Or the next. Okay, and thanks very much.
Bev, I have to say thank you and to Benjamin, because I've sat in on quite a few. And every time you listen in, you might have heard it before, but it kicks in something else. And you've got a different question, or it answers a different question. So thank you for doing this.
Yeah.
My pleasure. And thank you all for coming. I've been very inspired by the level of dedication among the ag and horde organizations. And I learn constantly from your questions and from Bev's, expertise in this area. So it's a learning experience for me as well. So I really appreciate it.
Okay, well, thanks, everybody. We'll talk to you later.
Talk to you
Good
later.
night.
Night.
Good night.